Hello, my name is Ian Wu. I'm an attorney with Goye Ruana Thompson. I've been with the firm for about 3 years, and I work primarily in the licensing department with registered nurses and licensed vocational nurses. Today we'll be talking about the registered nursing application process in California. Now, many nurses are coming from out of state and applying for licensure in California, or they're graduating program and applying for licensure in California. Either way, it's important to note that the California Board of Nursing does a strict background check on these nurses and determines whether or not there's anything in their record that might be cause to deny an application. So it's important to know that during this application process, before you apply, you should retain counsel if you have any issues or if there's any indication that you might have a reason to suspect something might pop up on a background check or as prior discipline on another license. Prior to July of 2020, the Board of Nursing required licensees to disclose any and all convictions on their applications and provide certified court documents and police reports to the Board of Nursing. After July of 2020, the Board of Registered Nursing California, they changed their policy to do the background checks on their own and to get the certified and court and police report documents on their own accord, which is less of a burden for licensees, but it does increase the processing times as the board's now taking it under, I guess, their control to do that. They do allow, however, licensees to disclose their own convictions and supply them with these certified documents, which we recommend doing in many cases because it does speed up processing times. The new law that came out in July of 2020 also prohibits the denial of a license for convictions that are over 7 years old or that have been expunged. There are certain exceptions to this, however, for serious felonies or convictions requiring people to register as sex offenders. But it's important to discuss with an attorney kind of whether or not a prior conviction you might have falls within these exceptions. Nevertheless, if you are applying for licensure and you have a conviction on your record that is eligible for a dismissal or an expungement, we always recommend getting that as part of the board's criteria for determining rehabilitation, and it might let the applicant fall into the exception where they can't be denied a license for having it expunged. So if a license application or an application for licensure is denied, the board allows for a license applicant to appeal that denial within 60 days of receiving that denial. And upon appealing it, they file what's called a statement of issues against that applicant. This process of getting denied and appealing is very drawn out and tedious. And it's something many applicants would have hoped to avoid. Unfortunately, we see applicants sometimes going into the application process and submitting their application without really knowing about expungements or getting off probation and subsequently being denied and having to go through this process. So once the statement of issues is filed, you're negotiating with the board essentially to have your license granted, but on some sort of conditions, whether it be a reprimand or probational conditions. So it's essentially that licensee getting their license granted, but with discipline on it on the get-go, which many nurses who go through nursing school, pass their boards, it's not ideal for a new nurse starting out in a new healthcare profession. So we advise any nurse who is applying to seek counsel if they have any prior convictions or discipline on another license, which would be required to be taken into consideration by the board in deciding whether or not to grant that application. In conclusion, many of our clients or people who come to us with questions are applicants for licensure in California, whether they be nurses in other states or nurses who are graduating. We always advise applicants with any issues that might hinder their application or result in denial to consult with an attorney or someone experienced in licensing so that they can plan for their application to go through to the board in the fastest amount of time and with the highest chance that they aren't denied.